Hi, Tony DeWitt here, Missouri appellate attorney, and I like to make the law make sense here on YouTube. Well, as much sense as it can make. Today, we are going to talk about a unique critter in the law called removal jurisdiction. So stay tuned. When someone gets sued in state court, and the state court lawsuit is based on a federal statute, then the state court can lose jurisdiction or the ability to hear the case on the basis of removal. Removal is a specific statute that grants to the defendant the right to pull a case out of state court and bring it into federal court. Federal question jurisdiction is provided for in the Constitution in Article 3. It specifically grants to the federal courts the right to determine questions arising under federal law, which really only makes sense. They should be the experts on federal law. But the Constitution also grants to the federal courts the right to hear cases between citizens of different states. It's called diversity jurisdiction. I will link a video that I did up here that talks about diversity jurisdiction, among others. And diversity jurisdiction simply means that somebody from Texas can sue someone from California, and if they sue them in state court, the person who is sued, who is from the diverse state, can then bring that case into federal court. Now, let's suppose that someone from Texas drives to California and runs over someone's leg and injures them pretty severely. And the citizen in California sues the individual from Texas in the courts of California. That may not seem fair, but that's the way the law works. It's perfectly fair to bring the person back to California to try that case. There is personal jurisdiction because the lawsuit arose from conduct that occurred in the state of California. But now it's between citizens of different states. So if it's sued in the state court of California, then the defendant has the right to bring the case into federal court. And the federal rules are usually different and often more favorable to the defendant than are the state rules. That may not necessarily be true in California or in any other state, but generally speaking, the federal rules are perceived to be a little bit more defendant friendly. That doesn't mean that the judges are defendant friendly. It just means that in most instances, federal courts tend to be perceived to be more defendant friendly. So there is a benefit to bringing it in. And again, this dates back to the founding when the Constitution was developed. And people thought, well, somebody who is in Georgia who causes harm in Maine may not be willing to be judged by a jury of people from Maine. And maybe a Maine judge would be more sympathetic to the people in Maine. So diversity jurisdiction was created in the Constitution, and it's carried forward by the actual statutes which grant jurisdiction in the federal courts. And those are found in Chapter 28 of the United States Code. Now, removal jurisdiction can be on the basis of either diversity or federal question. So once a person files what's called a notice of removal, as I said before, they go into the state court, they pick up the case, and they carry it over to the federal court. And they bring all of the documents from one court over here to the other court and file them there. And then the case gets heard as if it had been filed in the federal court to begin with but one exception. And that exception is remand. It is often the case where the defendant, or the plaintiff rather, will decide that, hey, that's not fair. We shouldn't have to be in federal court, either because the jurisdiction is not based on a federal statute, or, for example, because there is not diversity of citizenship. So I'll talk about a case that I was involved in without naming names. We sued a physician under the Missouri Merchandising Practices Act. And the Missouri Merchandising Practices Act says you can't engage in conduct that is deceptive. And what this gentleman did, or was alleged to have done, he never admitted doing it in court because the action settled. But basically, he was taking and reusing unused amounts of chemotherapy. He would sell, for example, a vial of Gemzar, a drug that is used to treat lung cancer, and he wouldn't use the full amount. You know, if it came in 1,000 cc's, he'd use 500. And I don't know what it comes in. I mean, this is just an example. And he would take the other 500 and use it for someone else, but he would sometimes charge them the full amount for the Gemzar. So he was, in a sense, double dipping, or at least that was the accusation. As I said, it was never proved. However, we felt fairly confident that that would be the case. And we cited in the complaint the fact that the FDA required that these drugs be properly labeled. And when someone was using reusing, I should say, a drug that had been previously used, they were effectively violating the labeling requirements. They were basically using a drug that was mislabeled or adulterated, I think is the proper term. So we made that allegation based on the federal regulations. We didn't make the claim based on the federal regulations. In other words, there was no liability under the FDA regulations. We don't have rights as citizens to enforce the FDA regulations. Only the Department of Justice can do that. But the defendant said, aha, here's the deal. You have sued us and you've mentioned this federal regulation, so we're bringing you into federal court. And the judge, who happened to be Nanette Lowry, a very smart, very good federal judge, a judge that I have both won motions and lost motions in front of, but have never questioned her integrity or her ability to get things right, she decided that that was not a proper basis for removal because the claim wasn't based on those federal regulations. It was based on the Missouri Merchandising Practices Act. And we were able to be remanded back to state court. And once we were remanded back to state court, we were able to settle the lawsuit. So that's how the remand system works. It works to pull it out. If, for example, if there is not complete diversity, for example, if in that situation, Dr. A's corporation had been a corporation that was set up in Delaware, and we sued the Delaware corporation and we sued the Missouri doctor, then the doctor couldn't remove it on diversity of citizenship because the corporation was not really a citizen of Delaware. Its principal place of business was in Missouri. So that's removal jurisdiction. It's confusing. It's complicated. It gives lawyers and judges and especially law students headaches, but it actually works to improve justice. Federal courts tend to move along at a good clip. They require people to meet time deadlines that a lot of times state courts are a little more lax on. And as a result, justice does tend to be a little bit more swift in federal courts. There are pluses and minuses in federal court, and it just depends on the venue and the judge as to how that works. But that's the story of removal jurisdiction. If you have any questions, please leave them in the comments down below. And so if you would smash the subscribe button over there and click on the top notification bell, you'd get a notification every time I release a video here on this channel. And while you're at it, if you'd smash that like button, I would really appreciate it. Smashing the like button makes you feel good all over. It doesn't cost you a thing. And more importantly, it lets people know that the content here is valuable and worthwhile and other people will benefit from it. So thank you for watching and have a terrific day.